Thank you for giving me the opportunity this evening to comment and provide an overview on two topics that are very near and dear to municipal clerks everywhere. In the interest of time, I'm going to provide a broad overview of the two topic areas, but certainly, as you have questions or if you have specific questions, obviously I'm available anytime. So please, please come and talk to me. So the first item that we're looking to focus on is the procedural bylaw. Oops. And we're really talking mostly about general principles that should be applicable to all procedural bylaws, and then some of the rules specific to the current Town of Tecumseh bylaw. So on your first slide there, certainly some of the importance is, firstly, to regulate and guide how council should function at meetings. Certainly not every procedural bylaw is all encompassing. So there's usually language in your procedural bylaw that provides for, in the absence of certain provisions, resort should be had to parliamentary rules. And the most common one that most of us are familiar with in some degree is Robert's Rules of Order. Another important function is council meets on a very limited basis and at limited times that it meets as a body. And so it's crucially important that council conducts their business in the most efficient or, expedited fashion as possible. Another important function of the procedural bylaws to ensure council's actions at its meeting are valid and legally binding. Another important function is that the meetings be seen by the public as being run efficiently, and that certainly helps to build trust in the public, confidence by the public in its council. And then certainly meetings that are run in accordance with the procedural rules and with respect to decorum and civility certainly tend to be your most productive and effective meetings. Next slide. So the role of council at the meetings, and I can't emphasize this more, that these are council's meetings. The meetings are a key focal point for the councillors, a focal point of each councillor's role and their obligation to the residents or to the citizens. So it's certainly important that, that the procedural bylaw reflects the fact that this is council's proceedings and that they have ownership over that. So certainly part of that is, proper preparation for meetings, voting at the meetings, and observing and supporting proper procedures. Certainly those are the keys, or some of the keys for council. Next slide. And actually next slide, if you can as well. The clerk's duties under the procedural bylaw, certainly agenda management is a key part of it. Maintaining an official record of all resolutions, decisions, and proceedings as required by the Municipal Act. And that includes bylaw management and management of the minutes. And certainly another key component that the clerk's office or that the municipal clerk provides is to provide that advice from time to time on parliamentary procedure. Next slide, please. So meetings, any regular, special, or other meeting of council where there's a quorum of the members present, or quorum of members is present, and the members discuss or otherwise deal with any matter in a way that advances the business or decision-making of the town. And an important note, the last note there, certainly under the Municipal Act, the clerk or either the clerk's designate needs to be present at all proceedings of council. Next slide, please. Quorum is a majority of the whole number of the members who are present in person or at electronic meetings, and so that brings you to 4 members. An advisory note, certainly for all councils, is our note there that a group of council members of 4 or more that either meet outside chambers or communicate by email or text could possibly constitute a council meeting, and that could potentially be in violation of the open meeting rules and the public notice requirements of the meeting. And that's in particular if that discussion or that group of emails or texts has the effect of moving forward the business of the town in a material way. Next slide, please. Real quickly, under section 4 of the current procedural bylaw, the meetings are held on the regular meetings are held on the second and fourth Tuesday. If it's on a public holiday, it's moved to the next following date. Generally held here in council chambers, but certainly the mayor, either by notice, and I believe it's 2 days, and then or council by resolution may certainly alter the dates or the meeting times or the locations. Next slide, please. So certainly the clerk's role is to deliver that agenda to council and post it to the website 5 days prior to the meeting, and that effectively serves as notice to the public of that meeting. Next slide. In order to maintain consistency and efficiency in the meeting, the general rule is that the business is dealt with in the same order as the agenda, but certainly there's circumstances that will arise from meeting to meeting where particular items may need to be moved up in the agenda or placed elsewhere. But generally speaking, the intention is to follow that order of business. Next slide. Special council meetings may be called upon by the mayor on 1 day's notice, or, and this is the wording of the current procedural bylaw, may be called by council on petition by the majority. And then it's even possible for the chair of a committee on notice to call a special council meeting. Generally speaking, as I'm sure we know, usually called for a specific purpose or a subject matter. At times, the special meetings or the public meetings are required on a statutory basis for public consultation. And sometimes either the subject matter is deemed to be important enough that council's being asked to focus on that subject matter at a special meeting, or just sometimes the topic matter may need, a commitment of time greater than what could be fit within a regular council meeting. Next slide. Same thing. There's a general order of business for special meetings that certainly can be changed if required. Next slide. The closed council meetings, so closed to the public or a private meeting. Sometimes they're also called in camera, and that's simply a Latin expression that means in chambers. But the requirement for closed meetings or the holding of closed meetings generally goes against the fundamental rule, right? The fundamental rule that all meetings of council and committees should be open to the public, except as related to the exceptions permissible, and that's under 239. And the language used states permissible or allowable because there's a discretionary element to it. Certainly, you may have some matters that council wishes to discuss that falls squarely within one of the exceptions of 239. But council or admin may still decide to hold that meeting in public. But if council feels it's necessary, then they have that option to hold that meeting in closed session. And usually the consideration is whether or not there would be prejudice brought to the town, or it's not in the best interest of the town to discuss that matter in open session. And a good example is actually this meeting under section 239 3.1. Council's allowed to go into closed session to have meetings related to training or education. And in some circumstances, a council may go into closed session for that purpose. We didn't tonight because there's certainly no apparent prejudice or harm to the best interests of the town. So what are the closed meeting exceptions? Next slide, please. So there's a number of them. There's a number of exceptions, and I just want to quickly go through some of the key ones. So if the subject matter being considered relates to some of these following matters, concerns about about the security of certain municipal property, certainly personal matters about identifiable individuals, discussions about either a proposed or a pending sale of land or acquisition of land. Certainly labor relations is one of those exceptions. Litigation, any advice, receiving legal advice, so subject to solicitor-client privilege. Sometimes councils will go into closed session because the subject matter concerns either a trade secret or some sort of type of proprietary information that's been supplied in confidence to council. And if it were to be disclosed, could bring harm or prejudice that competitive position or that the status of those negotiations. So those are some of the, and again, the exceptions are all premised on the ideal that disclosure in an open meeting would likely cause harm to the best interests of the town. Next slide, please. So certainly some of the, just again, to reiterate why council goes into closed sessions at times, and the reasons why mostly circulate around, observing and protecting privacy rights, protecting certain rights or assets of the town, which could be compromised if the information is released to the public, protecting bargaining or negotiating positions of the town, and to receive litigation advice or legal options. Next slide, please. Closed meeting procedures. Generally, well, in a closed meeting, the council is only permitted to vote on procedural motions or to give procedural direction to administration. No other decisions or approvals are permitted in a closed meeting. So there's and the goal is to try to ensure that what's occurring in the closed meeting are discussions, not decisions. And certainly as much as possible, that needs to be the rule to be adhered to. No formal voting that takes place in those council meetings. A motion, the rules of procedure do still apply to the extent applicable in those closed meetings. And a motion in open standard procedure is a motion in open session to move into closed, and to discuss the general nature of the matter to be discussed. And next slide. Closed meeting report. Councils coming out of that closed meeting have an obligation to discuss later in open session, at least in a general matter, how the closed meeting agenda items were dealt with. And certainly a consideration, and to some extent, it should be done where possible. Some matters that are discussed in closed session should come back ultimately and be dealt with or disclosed in public. That doesn't happen there's some information that's discussed in closed session that remains of a confidential nature, even coming out of the meeting. But there are some of those items where the confidentiality expectation or the need to keep that confidential is more of a timing issue. So perhaps that potential purchase or sale of land is in closed session, and the negotiations surrounding that are items that are discussed in closed session. But at some point when that purchase takes place or when that sale takes place, that item, not the discussions, but the action item of that purchase or sale are brought back in open session, typically through a bylaw, typically through registration of those documents in a land registry office, and thereby we're back in public on that matter. And then last note on closed meetings is certainly there's a code of conduct obligation on all members of council not to disclose any information or discussion that came out of that closed meeting. And certainly the risk is that there could be a violation of the code of conduct by doing so. Next topic I wanted to approach with council. Next slide, please. is disclosures of conflicts of interest. And this is the key provision is Section 5 of the Municipal Conflict of Interest Act. It states very briefly and the three main requirements that go with disclosing a conflict of interest. It states where a member has any pecuniary interest, direct or indirect, and is present at the meeting, the member shall, prior to the consideration of the matter, disclose the interests and the general nature thereof. Secondly, shall not take part in the discussion or vote on any question in respect to the matter. And certainly if the disclosure is being made in closed session, then the member has that further requirement to actually leave the closed meeting itself. And third requirement is the member shall not attempt before, during, or even after the meeting, should not attempt to try to influence that vote. So even after the meeting, a vote has taken place and a member that has declared that interest can't be seen as trying to further influence that matter. Next slide. A requirement that I believe came in 2018 is for members to file a statement of their conflict of interest and to file that in order with the clerk's office in order to keep a public record, a conflict of interest registry, which is available to the public. And that conflict or that registry, that written statement of what the conflict is and the general nature needs to be filed either at that meeting or as soon as possible afterwards.
Can I ask you just one question, so I'm not losing my train of thought on the conflict of interest? You'd mentioned that if the member is in conflict or feels in conflict, declares in an in-camera session, then would have to recluse themselves from the meeting entirely. If someone's in a pecuniary interest or conflict and it's not in camera, is it still good practice that they remove themselves or recluse themselves from the meeting itself?
Thank you, Mr. Mayor. Perhaps good practice. The only requirement is that they not take part in they declare they not take part in the discussion, and obviously they do not vote. But in an open meeting, they are still required, or they are still able to remain in that meeting. I know from past practice, in some instances, the counselors will usually push their chair away from the council table to indicate they're not actively taking involved in that discussion. So I think that may be up to the counselor if they wish to, like you said, fully recuse themselves, but there's no actual requirement for them to do so.
Just more of a comment. It's almost, I mean, at that point, I could still see influence in terms of just from body language and depending on the peers around certainly around the table that could influence the decisions that could be made by council. That's just my observation.
And through you, Mr. Mayor, certainly, the third requirement that prohibits, attempts to influence the vote either before, during, or after, may certainly be applicable. Body language may be certainly applicable if there was to be, a complaint filed that there was a breach of the act. I'm certain that the investigator would look at that and look at the language, the tone, because as you said quite clearly, it's body language can be everything in a meeting, and certainly depending on how they've acted, they may be in fact influencing without speaking a word. Next slide, please. So a pecuniary interest. What is it? It's technically not a defined term. It is the result of previous case law, but certainly it would include, in connection with that matter that's before council, it would include monetary benefits that will be received or could be received directly or indirectly as a result of that agenda item. It may also be, and that could be cash, or that could be some other value, maybe an increase in asset value related to that member's pecuniary interest. Next slide. And the Section 5 of the Act refers to both direct and indirect pecuniary interests. So what's meant by that? The direct interest can include, again, that connection or that conflict with that matter before council, either of the council members themselves, their parents, their spouses, partners, and it even extends to children. The indirect pecuniary interests, that commonly exists where the council member, again, with respect to that matter before council, has that conflict either as a shareholder, director, or officer of a corporation that's involved in that matter that's under consideration for council. And certainly, even if certainly it's not just in the corporate sense, but it would extend to situations where that council member is part of a group or an association. Next slide, please. So again, we've already spoken to this, the requirement that the member in a closed meeting shall leave the meeting and disclose that interest at the next open meeting. Any doubts as to disclosure, as to if disclosure is required, the Integrity Commissioner does have authority under the Conflict of Interest Act to look at those matters and may certainly be able to provide the counselor with that advice if they are unsure whether to declare an interest or not, or a conflict or not. Moving on to delegations, and this is Section 14E of the current form of the town's procedural bylaw. General delegations must submit a request to the clerk 7 days in advance of the meeting. Certainly, during COVID and certainly as part of the shift to hybrid forms of meetings, that requirement, not just at the town of Tecumseh, but with other municipalities, that's been flexed a little bit is as far as timing, and certainly we'll look at revising those provisions relating to delegations, but that's the current reading of the delegation rules. And then certainly, as always, a delegation can be heard upon council resolution at the meeting itself. The delegations are usually asked to confine their remarks to business stated in that request or business related to the agenda, and are usually limited to 5 minutes or 10 minutes for 2 speakers. And as always, that's subject to the mayor's discretion. Next slide, please. Certainly, there are some reasons why a delegation may be denied. Certainly, if outside the timelines, it may be a matter for which council doesn't have jurisdiction. It may be an ongoing labor or management issue. It may be a matter that's currently being dealt with or has been dealt with by the Committee of Adjustment. Council may have previously considered that matter already, and according to the wording of the current bylaw, they've considered that matter already within a period of 12 months from the last consideration. And obviously, litigation or potential litigation matters delegations can be denied for. And then probably one of the most common reasons why a delegation may be either denied or deferred is it's properly a matter that administration should look at first in order to research and be prepared to come to council with that delegation with advice or recommendations. Next slide, please. Motions or notices of motion, and this is addressed currently in Section 12 of the current version of the procedural bylaw. So it's exactly as stated. It's an advance notice. The bylaw states 3 days notice regarding a matter on which council will be asked to make a decision by resolution. Should be given in writing to the clerk in the form of a motion and prior to the meeting. And simply in a form of motion means a request that is clear and is an actionable item for administration to take. And certainly administration can assist in that matter as far as the wording itself for that desired motion that you wish council to consider. Next slide. We talked briefly, certainly COVID ushered in a host of changes to the Municipal Act to allow for electronic meetings and to allow for hybrid types of meetings in which those participating by hybrid count as quorum and have rights to vote. And so certainly the town's procedural bylaw is no different. Section 9A allows for electronic participation. The members who do participate electronically permitted to vote and definitely considered or counted as part of quorum. The council member is to provide the clerk with notice that they wish to, a 5 days notice that they wish to attend the meeting electronically. And certainly the public or delegations may participate electronically as well. So just briefly, as far as the mayor's or the presiding officer's duties at the meetings, and then moving quickly over to rules of debate or order. It's exactly what's stated: to preside over the meetings, to chair. So permitting questions through the chair, to put to vote all questions, sign all bylaws and minutes of council, rule on points of order, generally maintain order and decorum at the meeting itself, and guide the meeting through the agenda as that meeting continues, and to finally adjourn. Next slide. So the mayor, is presiding over that meeting, also presides over the conduct of the meeting and directs which member has the floor. Members must be recognized by the chair before speaking. And members, including and also including administration and members of the public, again, shall speak through the chair at all times. And the reason for this is, again, some of the same common purposes. This is going to help maintain that required order, that respectful discourse, and that civility, again, with the goal of being effective and efficient meetings in which the business is conducted. Next slide, please. Under section 410, just general information on motions. So it's a proposal to pass a resolution. Still needs to be voted upon. Obviously, we need a mover and a seconder before speaking to or having discussion specifically to that item. And with most procedural bylaws, subject to the discretion of the chair, the remarks to the motion under consideration should ideally be limited to about 5 minutes each. But again, that's at the chair's discretion. Next slide. Again, subject to the discretion of the chair, each council member should ideally on a motion only speak once to that motion. The mover usually has the right of reply or right of final reply. But again, that's a discretionary item for the chair. And then friendly amendments at times. And the goal behind that is to try to improve or clarify that the intent of the motion, and possibly improve the chances of it being voted upon and finally adopted. Key requirement of that, your original mover and seconder must consent to that friendly amendment language. Next slide. Yep. Some motions you might need to consider, and perhaps some of these do not have necessarily a history of being motions applicable in some of the council meetings, but some of your common motions, I'm just going to go through a few of those. The motion to table, so that removes the subject matter from consideration until the members vote to take it from the table, remove it from the table. And that could be for possibly an indefinite period of time, but a vote will be required to bring that matter back. And there may be a whole host of reasons why that matter needs to be tabled at that particular point. Next slide, please. Motion to postpone or defer. That's usually when that pending question that that motion on the floor for consideration. There's a desire to delay that to a definite time or event. Perhaps council wants some more information, or an event has to happen first. Sometimes it's just based on past practice, there may be a council member or maybe a couple council members who that subject matter is near and dear to, and they were unable to be present for that meeting. Sometimes that'll bring up a deferral so that that counselor can return and deliberate with the rest of council on that issue. Motion to refer, again, that can be a common motion, a referral back to administration, maybe in the course of the meeting and part of council's deliberations on that motion. Council feels there's more information, more investigation that should be considered before they finally consider a vote on that. This may not be used often, but this is a motion to reconsider. So this is a motion to requesting to bring back a matter that's already been decided or voted upon. And if a caveat that goes with this is if the action approved in that original motion cannot be reversed, has in fact been acted upon, then the motion cannot be reconsidered. The motion to reconsider can possibly be at that same meeting, or it can be at a meeting following the meeting in which that original vote took place. And most procedural bylaws will ask for what they call a special majority or 2/3 a vote on that motion. And there's usually a lot of procedural bylaws will have a limitation as far as time. For example, a motion to reconsider on a particular topic may only be brought once in a year. But the key caveat is that if that direction that council gave by voting on that resolution, if that action has now resulted, if the action is followed, administration has now actively taken steps on that, then it may not be possible to reconsider that.
Just a quick question on that. The motion to reconsider, does it have to be brought by a member of the prevailing side? So if there was a motion that was that somebody wanted to kind of for themselves reconsider their own vote, if that vote was what had been passed, does it have to be brought by a member of the prevailing side?
Through you, Mr. Mayor. In most procedural bylaws, yes. In most procedural bylaws, usually the mover and seconder on the motion for reconsideration has to be members that were on the prevailing side of that original motion. That's usually the standard. Yeah. And then finally, motion to withdraw. Sometimes a mover will change their mind depending on the discussion that has evolved. And if that's already been received, there's been a mover and a seconder on that. Normally, if you have absolute consent by the other members, then that can be withdrawn, or there could be a vote on that motion to withdraw. But normally speaking, the councils will operate on consent by that. And then just moving quickly to rules of voting. No member speaks further on a motion after that motion has been put to a vote or the question is being called. Members are to vote on every motion unless a declared conflict of interest. Abstaining or declining to vote under procedural bylaws is usually deemed a negative vote. There's no secret voting. In the town of Tecumseh bylaw, the mayor will usually ask members to vote by show of hand to indicate support or oppose, and then the motion and then the results is announced as either having carried or defeated. And then unless otherwise stated, voting is by majority. And then the other item that I don't think I have up there is your chair is entitled to vote. Your chair, and I think that might be the next slide, sorry. Yeah, a tie vote, motion defeated. But the chair may vote with the members on all questions. Sometimes it's commonly thought that the mayor only has a casting vote or only casts the vote when there's a tie. But that's not true. The chair may vote with the members on all pending questions. A recorded vote, that's when a member immediately prior to the taking of that vote calls for that recorded vote. So the clerk will definitely do a roll call and ask each member to answer whether they support or oppose the motion that's on the floor. And usually begin with the member who asked for that recorded vote, and then you follow an order through there. The key part behind the request to the recorded vote is that the names of those voting and how they voted, either in support or opposition, is formally recorded in the minutes. And all members, again, are expected to vote unless there's a declared conflict. Next slide, please. And then just real briefly on bylaws, a resolution usually applies and refers to a single act or direction of council, whereas that bylaw is a permanent continuing rule, which is to be applied to all acts and future occasions. And certainly in most cases, bylaws are preferred, and some cases are absolutely required to give full legal effect to those acts or resolutions of council. Next slide. And that's fine. Next slide, please. Oh, sorry. Looking for the slide. I think it's on 47. There we go. So last few comments on the procedural bylaw, and I believe this came out of the Clerk's Department Service Delivery Review. A review is recommended in order to obtain feedback and collaborate on revisions to update the current state of the procedural bylaw. Certainly taken in some observations or recommendations coming out of the review. Perhaps there's opportunities to update certain provisions or clarify certain provisions. The consultant in its report did identify certain issues to be considered for the review. And I just named a few there. It's not all inclusive, but appropriate references to parliamentary sources, some updated revised language considering motions and notices of motion, and then perhaps some further clarification or additions or revisions surrounding the rules of voting. And so as a result, there will be a report coming to council on February 14th. And we're looking for council to support the striking up of a council subcommittee to review that current procedural bylaw, provide that feedback and collaboration. And the reason why, again, as I stated at the beginning, ultimately it's council's procedural bylaw and the key tool to use to ensure the residents, the stakeholders, to ensure their issues are being addressed. And that's only going to take place if procedural rules guide and ensure that those meetings are efficient and effective. So that's the extent of this first presentation. I'd be happy to try to answer any questions council may have.
All right, thank you very much, Mr. Auger, for the presentation. Any questions or comments? Yes, go ahead, Councillor Houston and Deputy Mayor.
Thank you, Your Worship. I did make a couple notes here, and thank you for the presentation. A couple questions that I do have with regards to the BIA and special meetings. If they wanted to call a special meeting, they would follow the same rules in advance notice of 5 days, just as the council procedural bylaw. Is that correct?
So through you, Mr. Mayor, and to the councillor, are you referring to the provision that speaks of if a committee wishes to call a special meeting of council?
Well, my question
or just any meeting?
Yeah, and my understanding is the BIA would follow the same rules that the town would. So if they conduct business and either can't finish or they'd like to call a special meeting, just making sure that they're doing it correctly, they would then call special meetings, but then have to give 5 days advance, post it online, right? Just want to make sure that we're doing things correct.
Through you, Mr. Mayor, that's all certainly true. Committees of council, bodies of council The expectation with procedural bylaws is that they follow the same rules.
Okay,
And that extends even over to the code of conduct. The same code of conduct obligations that the members of council have extend to the members of the committees.
okay, thank you. My second question, with regards to closed meetings, I guess what is the procedural bylaw with regards to updates? If council has a question about a topic which is closed or we've discussed in closed prior, can that be raised in a closed meeting if it's not in the agenda? Or I'm just wondering, because I'm not clear if, there was something that we haven't heard of for, a while, and we're wondering, an update, what does the procedural bylaw say with regards to bringing up closed meeting topics?
Through you, Mr. Mayor. Generally speaking, the expectation is that only those items identified on the agenda may be discussed in closed session. So if the matter to be discussed in closed session relates to property matters under 239, then only property matters and to be, should be discussed. And that's the general rule. Certainly, there may be times where there's not a written report, but there may be a verbal report as an update, but it still needs to be reflective of the reason why you went into closed session. So section 239, I think 2C is land and property matters. So, that verbal report or update still has to fall within the confines of 239 2C. Otherwise, council's in a closed session that perhaps speaking on a matter that may still be protected by the closed rules, but the public wasn't given notice of that. So let's say the conversation turned and council now wanted to discuss personal matters about identifiable individuals. If that wasn't identified on the notice to the public, then technically that could be an issue.
Okay, so my question would be then, if there is a topic that we discussed in camera and I wanted an update on where that specific issue would be, what is my best course of action?
Again, if that matter that was discussed previously in closed session is still a matter that, based on the advice potentially of the clerk and the CAO, if that matter is still something that should be properly discussed in closed session, because some matters, again, it's a timing issue. Perhaps that first time council discusses the issue, it should be enclosed. Maybe that second time, it's a matter that can now be discussed in open. So it depends on what the matter is, but if it's a matter that still should be discussed in closed, then it needs to be on that closed agenda for that discussion.
I don't think I had my question fully. Yep.
Just to follow and tack on to Robert's answer through the chair. If you have a matter that you want to raise for a closed session agenda, you can just bring that to my attention or the attention of the clerk or the appropriate department head to whom it pertains, and then we'll organize that in collaboration with clerks and the mayor.
Yep. Okay. Thank you. And then my last question is just regarding conflict of interest and pecuniary interest with regards to drainage. I believe there is provisions within the Conflict of Interest Act specific to drainage that if council members sit on a specific drain, that there are specific provisions that that we're not required to disclose. But I just wanted to, it might be a very specific question right now that you might not be able to answer, but I just wanted to inquire because we had the presentation. So
Through you, Mr. Mayor. I'm not immediately aware of that, but certainly I can look at that and provide an answer for council on that.
okay, thank you.
Deputy Mayor, it was second, and then Councillor Jochen.
Thank you, Your Honor. Robert, question with regards to closed meetings. And right now we're requesting nominees for various awards, Dr. Bro Award and whatnot, and those names are going to come forward. To me, it's an identifiable individual. So I don't know if that's an in-camera session. We had committee appointments that was in a public session in the past. We've had an in-camera. because as a council, it puts us in an awkward position. A lot of people that are watching, even if it's an award, they don't win, they get placed, maybe they get nominated the following year, and it's almost like, how come I don't win? And they actually see all the names. Is that considered identifiable? Is that still considered public? I just always kind of have a, concern with, even as a council talking about different individuals with their resumes and whatnot and what. So I'm not sure, moving forward, if this is something that can be reviewed or not.
Through you, Mr. Mayor. My thoughts on that, and very, very similar to like you referenced the committee selection process. The fact that someone has applied in their name, they're applying pursuant to a public application. So I don't have particular concerns over that. But as you alluded to, if the discussion moves into identifying further personal information, so as you referenced, the resume of an individual, particular attributes or skills of that particular individual, my opinion has always been that should be properly in closed session. So if the body that's deciding on that matter should properly go into discussion, and then when they, however, not vote, but when they come out of closed session, that vote, the consideration of the names, the public names, the applicants, should properly take place in open session.
Okay, thank you. I think you clarified the difference. Committee appointments, you're applying in a public setting. However, the awards, you're being nominated. So I don't know if they know or not beforehand or not.
Me personally, I don't think it's an in-camera issue. It's a public disclosure.
Mhm.
But
That's why I raise it, because I know we've been in camera
Yeah.
before and then back and forth, but yeah, that, I'm fine either way. I just wanted to know, in terms of best practices, it's because it's identifiable or someone's nominating this individual to win this award. They didn't apply publicly to have their name, in a public session. So that's why, with these awards coming up, if that should be in camera, but.
Through you, Mr. Mayor. Yeah, again, I mean, as far as best practices, even in an award scenario, reviewing some of that underlying information to support that application, may properly or should properly be, I believe, in closed session still. And just to provide that assurance that identifying information, which again may be personal, and what's been done previously. Again, I reference committee appointments again, but it could be in the scenario of nominations for a particular award. That identifying personal information is still provided, to the body that's selecting, but it's provided to them in confidence and made clear that it's confidential information. Wouldn't really recommend that that's displayed in a public setting itself, though.
Yeah, thank you.
That's something I think we could discuss even further, but to me, it's somebody that if it's a volunteer award or whatever, for example, they volunteered for Big Brothers Big Sisters, they volunteered for the Heart and Stroke Foundation, they volunteered for, I mean, to me, that's not you're judging an individual to match the criteria or the mandate of the award. I mean, I would say if you get into other issues that are not mandated in the requirement of the award, yeah, I could understand that. Like if an individual puts, if it's a good example, if his name is George Santos from the 3rd District in New York, who lied about everything that he did to get elected, now you're getting into some real personal stuff. I would say, yeah, I think you certainly go in camera, but I think it's kind of one of those a discretionary thing, obviously for for the selection, and that's why I think it should be a discussion for another day on that particular thing, that it should be a committee bringing recommendations to council instead of council being put in that position.
Yeah. And through you, Mr. Mayor, I agree. It's not an across the board rule. It kind of needs to be considered case by case. There'll be some information. The information should be reviewed, and then, like you said, a discretionary decision made whether that ought to be disclosed or not.
If there's no further question here, but I think we're gonna have to reschedule the. Oh, Tanya, sorry. We'll finish up there. Or anybody else have a question on this particular issue? It's just that on the freedom of information, I think we'll have to reschedule that.
For sure. I will just be very quick. Thank you through Mr. Mayor. It's more just a comment in reference to declaring a conflict or pecuniary. I typically do over drains if my husband or brother-in-law or whatever are assessed on it. Just public optics, sometimes they are unfamiliar with the language and process. They may tune in and be like, oh, how did she have a say and even be able to discuss? She may have some influence on the decision, which isn't right. So I just declare it. And I'm not gaining anything. It's actually costing me money, but I just, for optics, declare. Sometimes that's best too.
I'll just. Through you, Mr. Mayor, and to Councillor Jobin. Yes, that's certainly what I've experienced before. Some councillors, either for optics or just out of an abundance of caution, will sometimes declare, certainly.
Okay. All right, nothing further. Then thank you for the presentation, Robert. And then we'll move on to communications on here, the bylaw 2213 procedural bylaw and the presentation to be received. Deputy Mayor Getty and Councilor Tonio. All in favor? Opposed, if any? That is carried. Nothing further. Go ahead.
And just for the minutes, Mr. Mayor, we'll just reschedule another session for the Freedom of Information Protection of Privacy legislation. Is that
Yes.
correct? Thank you.
Okay. Adjournment then is in order right now. Councilor Houston and Councilor Higginson. All in favor? Opposed, if any? Motion carries. Thank you. This meeting, this session is now completed.